If you're in a blended family looking to put together an estate plan, there's a lot of unique and novel issues presented in your particular situation that need to be navigated that separates you from the nuclear family estate planning. My name is Andrew Rowe of the Law Office of Andrew Rowe. I've been an estate planning attorney for 12 years, helping put together plans for both nuclear and blended family plannings. In this video, I wanted to show you some of the issues that arise in blended family, and also about what tools are available to help navigate those issues, and what some of the estate planning options are for you to be thinking about as you reach out to your estate planning attorney. First of all, this is not legal advice. What you need to know is this is a general video, and it's just meant to talk about some very broad topics that you can take into consideration. Ultimately, especially with blended family planning, as you're going to see what that I'm going to unpack in the video, it's really crucial that you have an attorney put together your estate planning topics, that you hire a practiced attorney to put together your plan. Blended family planning presents a lot of pitfalls and a lot of landmines. So this is a part I'm very passionate about, because in these cases, we want to make sure that it's done right. Now, I wanted to talk about what some of the issues are with blended family planning. Basic estate planning assumes a nuclear family, which can have some basic assumptions to it. Most nuclear family planning says that on the death of one spouse, all property is transferred and owned by the surviving spouse. And then on the death of their surviving spouse, all of this combined marital property is divided to the children they leave behind. Well, we've got a few issues with that. If you have a blended family, you have competing interests and unfortunately not an infinite amount of money to go around. You may be wanting to provide for your current spouse, maybe depending on your real estate, your investments, your finances for their own well-being, but it might also be at the expense of providing for your children or your separate children. You may also be concerned that you do not want your spouse to be able to remarry and decide what to do with the property at that point. You may want to limit your spouse's ability to change the plan and oust your own children if you die first. So these are some of these issues. There are inherent conflicts of interest that happen with blended family planning. And in fact, I sit down my blended families and I talk about those conflicts right away, because to give property to a surviving spouse is at the exclusion of giving it to your children, which means that surviving spouse gets the property. Are we going to limit that ability? Well, that also means that the property going to the spouse, if it's limited, means that one of my clients isn't receiving a full share of an estate. Unfortunately, we just don't have infinite resources to work with in these cases. Next, I'd want to unpack what packages are available or techniques of estate planning to accomplish anyone's intentions. Estate planning really boils down to either setting up a will or a trust, or a middle ground of relying just on beneficiary designations. A will and a trust are two documents that have a similar function. They both state, upon my death, here's what's going to happen with my property. And it appoints a responsible party to go carry out those intentions. So their structure is pretty similar. They say the same things, but how they're carried out are very different. A will, which is a common distribution technique, would say, upon my death, divide my property, and here's who my responsible party is to go carry this out. A will, however, has to go through what's called probate, a long court process, in order to carry out all of the intentions and divisions that you put down in your document. Probate itself has its own procedures and jurisdiction. It involves a judge, it involves public hearings, it involves notices, and because of all of the procedure and red tape involved with it, it's expensive and time consuming, and in a case of a blended family, it does increase substantially the likelihood for any sort of disputes or contests. Especially in Kansas, if we are providing for a spouse or for children, probate requires us to notify all parties involved with the process and give them opportunities to object along the way. So if you wrote a will that says my spouse gets everything upon my death and your children don't like that, well, if we're using a will, we have to give the will to the kids, and they'll be given a notice that says, if you disagree with this will, show up at this date and time. We have to schedule the hearing to allow them to argue and object to the validity of the will. And in my experience, you don't need an attorney to show up to those hearings to wreak havoc and increase those legal costs. I've seen plenty of cases rack up 10 times legal fees from people who dispute the validity of wills or show up to object to these proceedings, and they don't have an attorney. So going the route of the will, if we're anticipating any sort of disputes or contests, is something I strongly advise against. And especially in a case of a blended family where you inherently are navigating conflicting interests, I very, very rarely would ever recommend setting up a will in these cases. So the alternative then is either avoiding probate through beneficiary designations or by setting up a trust. So I'm going to talk about this middle ground of beneficiary designations. Probate can be avoided and estate planning objectives can be accomplished through beneficiary designations. Every account that you have, real estate, businesses, just about everything you own has the ability for you to designate some sort of pay on death designee, transfer on death beneficiary, or some sort of joint ownership. By designating a beneficiary on a bank account in life insurance and retirement, you're telling that institution, on my death, write a check to this beneficiary. And that solves some of the problems. It does say who the owner will be upon your death, but it leaves a lot to be desired. So in my line of work, I do get to see where these type of approach fails. Beneficiary designations lacks nuance. You're saying to the bank, write a check for the total amount in this account to this person. Maybe you can divide it and say half here, half there, but it doesn't allow you to do something as complicated as saying, I want income to go to this person, I want principal to go to this person after this person dies. Or it doesn't say, well, what if this person's deceased or incapacitated? What if I want a decision maker in charge to double check because really I want my spouse to benefit during their life, but ultimately to get to my kids? It doesn't allow for any sort of nuance like that, which might be required in a blended family situation. So ultimately, I also stray away from ever recommending really relying on beneficiary designations alone for an estate plan in a blended family situation. That leaves a trust. So a trust is like the will, that it's a document that defines upon death how your property will be divided, under what conditions, and who your responsible parties are to carry out this division in the administration of your estate. Unlike a will, like I talked about, the will has to go through probate. A trust, by its design, is intended to stay out of probate. All of its terms can be carried out outside of that procedural process that's expensive and time consuming. There still will be a trustee who has to go through certain steps of administration, but the way they wrote the rules is that this administrative process isn't done through court. It also means that we don't have to pre-schedule these hearings to allow for contests. In reality, it makes trusts more difficult to contest and object to. It puts the burden on the objectors to hire an attorney and create a case and make their case. So the burden is shifted to anyone who would be objecting to convince to hire an attorney or to file a case to try and object to it, rather than your responsible parties being legally responsible for scheduling hearings and allowing for objections. With a trust, you can allow for more contingent distributions that allow for more nuance. One technique that's available that you can utilize in a trust is to say that when you die, we're going to take your property, or maybe you've got a retirement account or life insurance policy. We can take that and put it in investments, let it grow, and all the growth, all of the income goes to the surviving spouse. But then when that spouse dies, it goes to your kids. And we can even lock it in place. That way, we know that your spouse will get an income stream, but she can't go in and her creditors, her future spouses, her children wouldn't be able to have a say what happens to the principal. That way, we have some property set aside for your children. That way, we know they will inherit. Within a trust, the sky's the limit on how you come up with distributions. So it allows for some contingency planning. You can pick what happens when one spouse dies before the other one, what happens when spouses die together, how we want property to be divided. We can also say that certain portions of property would go to the surviving spouse and some go directly to the children of that first spouse to die. Or we can set it up to where a certain portion of property is put in a distinct trust and its terms are locked in place, so we make it irrevocable. We can say that the income produced from an investment goes to the surviving spouse, but we really want the main body of this trust, we call the principal, to go to your kids after your spouse dies. We can set it up to make sure that there will be an income stream of a certain portion to a surviving spouse, but that we have some property hard set to go to your children upon your death. That is to say, some blended families would look at it and say, it's not worth the complication. I don't need to have things set in stone so that my spouse cannot say what's going to happen with their property. If the complication isn't something you're looking for, you can still look at the risks associated with it and say, I'd rather just treat it like a nuclear family. I hear this pretty often, that they look at it and say, her kids are my kids are their kids, and honestly, I'm not worried about locking the inheritance in place for those future children. I'm not too concerned about disputes because we've all been together. I don't think the money's going to divide us. You, of course, don't have to add all of this complication. You do need to make an informed decision about it, but you still can choose after being told all of the risks associated with it and all those potential conflicts that could arise. You may look at it and say, I'm not worried about the conflict. I'm not worried about step parent and stepchild, my children going after my spouse or suing each other about who should get the property or arguing about it. If you're not worried about that, as long as you're informed, that's fine. We can set up a more simplified plan or treat it like a more traditional nuclear plan that says everything to spouse, and then when both spouses die, split to children. Alternatives can be sought, but it is important to know that we are navigating these potential conflicts with informed decisions, looking with a clear view. You're going to know your family, know whether or not you're worried about potential disputes and contests between step parent and stepchild. And you're going to know whether or not there will be any form of disputes and know how much coverage you're going to want to account for providing for your spouse versus your children. That's one of the crucial parts for hiring an attorney in this process, because knowing your options and applying it to your situation is going to be one of the most important parts of your estate plan, especially. That being said, there's no one size fits all, especially for blended family planning. Feel free to reach out today. Our firm has been putting together blended family plans for over a decade. If you'd like to talk through the options available for your unique situation, reach out to our office. We'd be happy to get you started on your estate planning process and get you started off on the right foot.